This video explains the key facts and major holdings in the case of Duffy and Google Incorporated. In this matter, Dr. Janice Duffy brought an application against Google Incorporated in the United States and Google Australia Proprietary Limited. This was a judgment of Judge Milstead of the South Australian District Court on 15 November 2011 and is an application for an interlocutory injunction based on an alleged defamation occurring online. Google Search is based on an automated system which essentially indexes web pages, storing that information in a database. When a search is made by the user, keywords and queries are matched with the index to generate results. On closer inspection of these results, we see that the title of the located web page is here, and what the judgment refers to as a snippet taken from the content of the website is here. In February 2009, Duffy discovered that Google searches of her name or variants produced search results which contained material about her of an alleged defamatory nature. On 12 September 2009, Duffy notified Google Incorporated and Google Australia of the results and requested their removal, following up on a further 7 occasions. Google Incorporated responded on 7 October 2009 and 16 December 2010 saying that they would not remove the links. On 16 February 2011, Duffy instituted proceedings in defamation against Google Incorporated and Google Australia. Duffy filed an application for injunction, which is the focus of this case, on 24 May 2011. She requested that, firstly, the removal of the impugned URL links and snippets from Google domains accessible in Australia, and secondly, that any new URL links of a similar nature be removed within 3 days of her notification. The injunction was brought on a number of grounds. Duffy contended that further material had been published since the defamation proceedings commenced, that she was unable to find work and feared potential employers would discover the material online, that the stress caused by the material exacerbated her numerous medical conditions including depression, that she had become socially withdrawn as a result of the humiliation she suffered, and that she would be devastated if her elderly parents discovered the material. His Honour noted in his view there was a serious question to be tried on the substantive application. His Honour did not, however, make a determination on the issue raised as to whether or not Google here was a publisher of the impugned content, but in refusing the application for injunction, His Honour made findings on 5 main points. Firstly, that the public interest in free discussion of matters on the internet weighs against the grant of the application. Secondly, there is nothing to suggest that, if successful at trial, damages will not be adequate. Thirdly, the injunction would not necessarily prevent injury to the plaintiff in that the material could be accessed through other search engines and remains on the host websites. Fourthly, there was no immediate urgency to the matter since the evidence suggested that Duffy was aware of the material as early as August 2008. And finally, the breadth of the orders sought were so wide that they became impossible to fulfill. The application against Google Australia was also dismissed because there was no evidence that Google Australia held any control over the removal of the links. His Honour also noted that had they had control, the application would fail on the same grounds as with Google Incorporated. Thank you for watching.